From Flourish DX, this is the Psych Health and Safety Podcast. With workplace mental health becoming a safety prerogative, this is the source of information on psychological injury prevention and health promotion.
Hi, and welcome to the Psych Health and Safety Podcast. My name is Jason Banshee, and I'm one of the hosts of the show. The aim of the podcast is to rapidly increase the knowledge and application of psychological health and safety in workplaces worldwide. To help with this, we have regular guests from around the world who are leading the way in this important area. But before I introduce our guest and topic for today, allow me to introduce my co-host, Joelle Mitchell. How are you today, Joelle?
I'm doing all right, Jason. I ran out of coffee beans at home, so I didn't actually get my first coffee till I got to the office this morning. It was good that you weren't here.
Yes, I'm glad I came in a little bit later today. I had to do the drop-off this morning, so I avoided that risk.
You did, yeah. Had a good time in Melbourne last week. Got to meet Alicia in 3D rather than just on the screen, so that was good.
Yeah, I still feel like we missed an opportunity to put you back to back. You're both wearing heels. I didn't feel it was appropriate in a nice restaurant to ask you to take your shoes off and stand back to back so I could get the photo. Was
the shoes the only reason you thought it would be inappropriate to do that?
Yes. Was there other reasons?
Probably.
Okay.
Yeah.
I reckon it's a
why don't you think about it?
I try not to dwell on these things. But no, I reckon it'd be a dead heat between you and Alicia.
Yeah, I think so. I think it's pretty close.
Yeah. So we won't say anyone's the winner or loser in that one. The only loser is our listeners, I feel, that they don't know who's taller out of you and Alicia.
Well, I feel like the only loser is you, who's obsessed with people's heights.
You're calling me a loser.
Is that what I said?
Okay. No.
I don't feel like height is something you can win or lose. It's just you are what you are, Jason. You're bordering on discrimination right now.
Heightism?
Yeah.
I still employed you, didn't I?
So?
Maybe it was an affirmative hire. I don't know. We needed more height diversity in the office.
Well, we've got sort of extremes now, haven't we?
We do, yeah. When you have Dutch genes, there's generally some tall people around. And then when you're Polynesian, you'd expect them to be taller, but Joelle's quite short.
And also not Polynesian.
Yeah, but from Vanuatu.
No.
Family heritage. Anyway, moving on. Hey, look, we've got a really good guest today. We should probably let her in.
I think that might be a good idea, Jason.
Yeah, I think so. Yeah. Before I hurt myself any further.
Yeah.
Okay, so this person has spent more than 25 years working in health and safety law. She's a board member for the Emergency Services Foundation, a senior fellow at the University of Melbourne, where she teaches workplace health and safety law, and partner at Maddocks Lawyers. Welcome to the podcast, Catherine Dunlop.
Thanks, and thanks for having me. I'm very excited to be here.
Yeah, now, Catherine was saying off air, I thought that you were the first lawyer on, and then I got reminded we've actually had a number of lawyers on previously. But really interested given the high-profile case that we're going to be talking about today and your understanding of it. So really looking forward to unpacking this one today.
Excellent. It's a really interesting case to talk about and a very sad one as well. We should acknowledge. Yeah.
So before we get into that, Catherine, what podcast do you like to listen to?
Well, obviously yours.
Obviously.
And I do, obviously. And I do nerd out. The wonk gene is strong in our family. So not only do I listen to a number of safety podcasts, but I also inflict podcasts on my child. So he's probably not as interested in the safety ones at age 9. But I was talking to him about this, and he and I have particularly enjoyed a podcast that's a few years old now, but from the BBC called 13 Minutes to the Moon. So the first season was about the moon landing and the second season was about Apollo 13. So if you're interested in that sort of stuff, or you have a scientifically inclined child like I do, highly recommend it. Good for long road trips. My other favourite, I'm an old film fan, is one called You Must Remember This, about history of old Hollywood, although the last or the current season deals with the influence of adult films on films of the 1980s. So that's definitely not one to listen to with your child in the car.
Good to note.
Yeah, I wouldn't start with that season if you haven't heard it before, but if you're a film fan, it's really interesting.
Cool. Well, can you tell us about your professional career, please?
Yeah, so I after finishing my law degree, I commenced and did my articles, and I was originally planning to be a litigator, and I kind of strayed a little bit into safety work within the first few years of working because I did a number of quite high-profile coronial inquests, mostly acting on behalf of public sector clients who were using an inquest to kind of advocate for greater public safety, particularly in fire safety. So I had done a number of those. I'd also acted in a number of quite large royal commissions. At one point, I had someone tell me that they thought I was going to manage all of the acts of God in my career because I'd done fires and floods, and I'd done a mouse plague, I'd done a range of different things. But as increasingly doing more and more safety work. So really for probably most of my career, I've been focusing on helping clients with the full spectrum of health and safety work, from the kind of preventative training work through to doing some prosecution work for prosecutors, to defence work for clients, incident response, and of course the things I really enjoy, how do we make work better? How do we make work safer? How do we have those sort of conversations? So I really enjoy all of that. I really love teaching health and safety. So I've been teaching for the last couple of years at Melbourne Uni for the postgrad subject, and that's been fantastic. And I also serve on some boards. So the Emergency Services Foundation, you had Susan on as a guest a few weeks ago, so that's a cause that's really close to my heart. But I'm one of those lucky people who has found something I really enjoy. I like working with my clients. I work with a great team, even though sometimes the work we do is necessarily reactive and tragic because we get called in after something horrible has happened. I really like working with clients to try and get, it sounds trite, but get the best out of that and work out how they can work to prevent that again. So it's always interesting, and as you guys know, safety work is never boring. And the capacity of human beings to behave in strange and odd ways and create risk is never ending. So that's that in itself is challenging.
Yeah, great.
Yeah, no, it's definitely an interesting field. And like you say, whenever you've got people in the mix, then unpredictable things can happen. So,
Absolutely.
yeah. Now, Catherine, the whole reason we invited you on the podcast is you co-authored an article about the recent High Court decision on an employer's duty of psychosocial care.
Yes.
So in particular, we're talking about the Kozarov, I'm hoping I'm pronouncing that right, case.
So.
Yep,
Yes.
so Kozarov. So could you give our listeners who haven't been paying attention to that particular case maybe a brief summary of what that was all about?
Sure. So this was a case involving an employee who worked at the Office of Public Prosecutions, and she had made a claim in relation to her PTSD and major depressive disorder. So she made a claim of negligence, breach of contract, and breach of statutory duty against her employer. So it's not a typical OH&S prosecution, it's a compensation claim. So the rules and the law applying is slightly different. So I want to take you a little bit through that framework because I think there are some interesting parallels, but there's some divergence as well. So it'll be interesting to see where we end up there. This case was interesting because at first instance in the Supreme Court of Victoria, they found for the employee. Then on appeal, the Court of Appeal said that they were conscious of what they called litigious hindsight, and they reversed that decision. And then on appeal again to the High Court, the High Court found for the employee. And so fairly short decision from the High Court, but an interesting one. So this involves someone who worked at the OPP, and I just want to acknowledge at the start that the work of our public prosecutors, whether it's in the sexual offences unit like this employee or more generally, I think is often unacknowledged for the really important work they do in terms of keeping us safe and the really high workloads they had. And so when we talk about some of the factors in this case, I think whatever we say, we can see that we've got good people trying to do their best, but nonetheless, we have someone who the medical evidence said had suffered these quite significant mental health injuries or psychiatric injuries. The employee's case was that when she was working at the Specialist Sexual Offences Unit, and she worked there from 2009 and through to 2012, she was not screened or supported or protected, and her employer had failed to implement their Vicarious trauma policy, had failed to respond to her concerns about work and her health, and to fail to have acted when they should have been on notice that she was not doing well. And the court really looked at this, or all the courts that looked at this in relation to kind of two aspects. One, whether the employer had a duty to undertake reasonable steps to avoid or minimise the risks to her mental health. And secondly, whether or not any particular points they would have, if they'd gone to her and talked to her about what they were observing or what her condition was likely to be, and perhaps given her access to a clinician, she would have accepted an offer to rotate out of this specialist sexual offences unit, and that would have avoided exacerbating her PTSD. So the reason I'm just giving you that detail is that the law, up until we heard from the High Court on this case, was that it was kind of accepted that as part of your employment contract, your employer is entitled to assume you'll perform that contract unless there are evident signs of a risk of psychiatric injury. And so one of the questions in this case was, in effect, when were there evident signs? And what I think is really important in this case is that for at least two of the judges of the High Court, they said for some occupations, the risk of injury to someone's psychiatric health is evident from the start. So people working in sexual offences units. So that's not something that was picked up by all the judges, but I think is a really important thing to note. It's what we expect in health and safety law, but it hasn't quite made it into workers' compensation law yet. Anyway, let me tell you a little bit about this particular individual. So she had worked in this specialist sexual offences unit. As you can imagine, the work is horrific. So it involves about half of her work dealt with child complainants. She was seeing disturbing images on a daily basis. And she was working very long hours. So the evidence was it was not uncommon for her to be working until midnight or 1 or 2. And in one instance, she was working till 4 a.m. This woman also had been subject to family violence. She and her partner had split up, and she had 2 small children. So, I mean, hats off to her for a high workload and doing all of those things. The other colleagues in her area also shared her concerns about the workload. So one of them described the workload as being horrendous, very demanding, challenging, constant, unabating, and very, very taxing, and in hindsight, untenable. Right? So really high workloads, pretty awful work that most of us never have to see. There was a policy within the OPP to deal with vicarious trauma, and it talked about trying to avoid long hours, having a manageable caseload, and encouraging rotations. They also had the offer of EAP support. So I remember when going back, over a decade ago, and I think our thinking on EAP has got a lot better. But the EAP support was someone who could walk around and would come into your office and talk to you. And the kind of evidence from the case was that anyone could see the psychologist sitting in your office through a glass wall. So there was an element of embarrassment about it. So perhaps it wasn't utilised. And also, if you were incredibly busy and you were at court, you couldn't see the psychologist because you just couldn't make time. There'd been a workshop that had been done on vicarious, on risks generally, where the employee's evidence was she remembered there being a discussion about doing things like yoga and pottery classes. So,
we're fans of that on the podcast.
With all that spare time that she had.
Well, that's exactly right.
I know she finishes work at 4 a.m, so she could probably
squeeze in a hot yoga class between then and the kids waking up. Yeah,
for sure.
Yeah.
No, sorry, I'm being
you like to
facetious.
think, don't you, that we've moved past the yoga and pottery class thing, and certainly this is at a point it's like 2009, 2010, but my goodness.
People think we're joking when we bring it up on here, but it's still, even today, it still happens. So
I know it's Anyway, interesting, the consultant who did those sessions actually wrote a memo saying, I can see amongst the people there's some issues, and I think you need to address vicarious trauma within this specialist sexual offences unit. There was also, lots of issues around this time about acknowledgement of the workload and those concerns. But interestingly, the managers of that unit were unaware of the vicarious trauma policy. So, just that issue that often happens where we have lovely things in writing, but then we don't actually live them. What's really interesting, I think, the thing I think is the most interesting point about this case was that the employees in this unit got together in 2011, kind of a meeting after work, as I recall, and had real concerns about workload. So they actually wrote a memo to management talking about the workload, talking about the lack of resources, and they did make a reference in there to stress. And so one of the issues in this case was Was that enough of a trigger to be this evident sign that you were on notice of risk of psychiatric injury? And really, I think the courts didn't really grapple with this. In fact, 2 judges of the High Court said that the mere, mention of overwork is not enough to put employers on notice of the risk of psychiatric injury. I think that's really interesting because that flies very much in the face of our understanding of psychosocial hazards and the new approach we're likely to have before long Australia-wide, and dealing with people saying, I'm working too hard, I can't cope. Right?
Yeah, because if you put it in, if you think about if it's a physical health matter, if there's a group of employees or a health and safety representative that brings that up to the employer, then they have an obligation, right, to investigate and correct, right?
Absolutely.
Yeah. So under the
what
new
this
psych
judge-
health regs that you reference, then that will have to be dealt with in the same way.
Exactly. And we would, we would label it, we would call it high work demands, and we would call it fatigue. And when they would then do, a good risk management process would identify what that represents. And what these judges say is, in an ordinary workplace, a reasonable response by a reasonable employer to complaints of overwork would not require that psychiatric health be assessed. So I think that'll differ. And I think it's a really interesting issue, because in a COVID mid-COVID environment with labour shortages, there are lots of places which have real issues with high work demand, and where, my advice would be you absolutely should be thinking about what that represents and what hazard that is and what you can do about it. Even if it's just to exhaust all your options, you at least need to think about those things. So
yeah, I find it really interesting. Yeah, I find it really interesting though, Catherine, how you mentioned earlier how, as part of their policy around protecting against vicarious trauma, that one of the controls was reasonable caseload, where quite clearly they didn't have a reasonable caseload.
That's exactly right. And so there's evidence that, for example, the reasonable caseload for, certain sorts of solicitors would be 20 files, and some solicitors had 100 more files than that. Wow. So they're just extraordinary. And I think there's also some evidence about that cumulative effect of overwork and fatigue and high work demands on PTSD. So, I'm no clinician, but I can't imagine that makes things any easier. So, we have this evidence from the employee herself of the kind of physical symptoms that she was suffering, overwork, fatigue, bad dreams, being hypervigilant around her children, the things that one can imagine if you were doing a role like this, and what her, how she felt. So, anger, very low job satisfaction, despite the fact she was very passionate about her job, and inappropriate thoughts and flashbacks. So that's all around this kind of period before things really kind of come to a head and she leaves the workplace. But, there were some steps that were taken by management to try and increase staff levels, but there really wasn't a dialogue here about what that meant for the mental health of the workers. So, there was EAP, there'd been these sessions, but no one is putting 2 and 2 together and saying, well, do we need to do more in this space? And there's even some really interesting kind of comments from the managers. And again, let's accept these are overworked people themselves trying to do their best, but saying things like they wouldn't inquire about a solicitor's health system because it would put someone on the spot and it would be intrusive, and they might think I've got a bias against them and I'm not going to go probing. And they're all adult full-time employees and they know what processes we've got in place. Or someone else who said, it's not my role to ask anything about someone's mental state. It would be intrusive. It's confidential. It's between them and their doctor. So I think we get this flavour of quite a kind of passive response to these health and safety issues. And so then we have a situation where our employee takes some leave, comes back to work, actually applies for a promotion and is successful. And to some extent, that's kind of counted against her in some of the judgments from the Court of Appeal, because it's seen that, she's keen, she wouldn't have rotated out of the area, she liked the work, and therefore she wasn't taking steps herself to mitigate the risk. But we get to February 2020 and she's flagged a range of issues. She seeks a transfer. She has a fairly terse kind of communication with her boss. She leaves work. There's some failed return to work efforts, but she doesn't return to work in a substantive role, and that's the end of her career at the OPP. So, you know, a really sad kind of situation when we look at all of that, because we as health and safety people would say, with thinking about our duties under the legislation, well, clearly there were warning signs and clearly there were things that can be done. What the court here had to do, though, is to try and work out whether the existing law meant there was a point of time at which there was warning signs. And what the High Court really did was say, we accept that had she been given advice earlier, she would have acted, and therefore her PTSD wouldn't have been exacerbated, and therefore she's entitled to compensation. So if you're reading the case, that's why there's so much focus on this timing issue, because it's really important. But I think from a more proactive health and safety perspective, we can read it and just look at it as a really sad example of overworked people suffering and you know, just cumulative effect of all of these issues.
Yeah. I think we'll come to another question I had later on, so I'll let Joelle ask the next one. But thank you. That was a really good summary, and like you say, no one should have to go through that. It's really horrible to hear that it had such a negative impact, and obviously it's going to have long-lasting impacts on her as well.
Yeah.
So it's good that it's finally kind of reached a conclusion, because I can imagine like having to relive all that, going through the processes of the, you know, the courts and the appeals and a High Court. That would be quite hard for her too.
Yeah. And I think we also need to remember this is reflective of a point in time. So we're talking about incidents that are a decade or more ago. We've moved a long way in our thinking about these things. And I'm sure many of the things that we're talking about in the facts of this case are not reflective of what's happening in many workplaces, although, as we've said, I'm sure some of them there's still legacy issues.
Yeah, so I think to that point, you know, I've read a lot of online discussions about this case. One point that gets raised fairly often is, well, if you're working in sexual offences, it's inherently traumatic. You know, you're going to be consistently exposed to traumatic content, and there's not very much that an employer can do about that. So do you have a response to that?
Yeah, look, I mean, I think there's some degree of exposure, but it's not much different from a lot of other workplaces where we have people exposed to hazards, whether you're working in a hospital or you're a police officer, you know, or even you're working in a GP clinic, you'll be exposed to some inherent risks as part of the role. This one you might say, well, there's a higher proportion of it making up your daily activities. But I don't think it means that harm is inevitable and that there are things that employers can't do. So I think we have to acknowledge there's a duty there. And so then the question is, what are the things that we can do? And I always love that great quote about, you know, what's reasonably practicable for an employer to do is to have this active, imaginative and flexible approach to dangers. So we're constantly actively looking at the risk and actively looking at solutions. We're imagining worst case scenarios and working back from then to what can we do. And we're flexible in our thinking. We will try new things. We constantly review procedures. You know, there are employers who work with situations of vicarious trauma who do have great procedures, great support. And it may be that means that people get rotated out of the area for a while and that you don't work in it for too long. And that brings into question industrial relations issues and all sorts of issues of that nature. But I do think it's an obligation. You know, and I've worked on matters that have involved very significant vicarious trauma. So I had a very large team of people working with me when we acted in the Victorian Bushfire Royal Commission for as part of the state response, but for the Country Fire Authority. And so, you know, we saw horrible pictures, we saw terrible evidence, we spoke to people who were traumatised. And, you know, to be clear, I'm not saying that's anything akin to what those people went through or working with images of child sexual offences. I'm not saying they're akin at all. But, you know, you put things in place, you review them constantly, you keep an eye on your people, you have those conversations and you don't treat them as intrusive. How are you going? How did you find that? Do we need a break? What do we do? And I think it's about giving employers the message that it's okay. In fact, it's essential to have those conversations. And then, what does that look like? This is a very long answer, but I just think I don't think it's an answer to say, well, we wash our hand, it's inevitable, because these people are doing work that most of us couldn't do. So we need to find everywhere we can to support them.
Yeah, absolutely. And I think, something that I've been thinking about with this as well is, the duty to conduct monitoring for health.
Yes.
So if we know that somebody's job involves exposure to, particular chemicals or radiation or noise or whatever that might be, then we do actually schedule them for regular screening and monitoring of the, the known health effects associated with that exposure. So why should that be any different for roles where we know that there's going to be exposure to traumatic content?
I think that's exactly right. And I think it also goes to one of the kind of key findings of this case, that had she been told and given some clinical advice, she would have acted differently. And I think that's a really important part of it as well, educating people on what to look for. And in some cases, talking to their family about what to look for. These are the warning signs. This is what we should be keeping an eye on. If you're having these things, it means you have these symptoms. And we manage the expectation that you're doing this work. If you're in a sexual offences unit or you're dealing with particular trauma, you're here for a certain period of time, but it's necessarily the case that we will need to rotate you on, because that's what good practice tells us we should do. Now, you might think you're more resilient than that, but as a general rule, that's the expectation. And so we then have to design the role so that people aren't penalised by moving and transferring, and we don't reward people who hang in there for long and may be more resilient, and treat that as something that's actually a preferable characteristic, as opposed to perhaps a personal quality of resilience that some people have and other people don't have.
Yeah, Catherine, to Joelle's point though about the monitoring,
Yes.
so hearing monitoring, for example, if you're regularly exposed to noise in the workplace, what do you think about this movement then? If we're taking a health and safety lens to psychosocial hazards, rather than just having EAP as available, if people are concerned about themselves, having actually mandatory monitoring when there are these, very much foreseeable, risks that they're exposed to and as part of their normal role?
I think it's a very good idea generally, and I think it's appropriate. And that idea that you think about job design, inherent requirements, and then you have something to measure against, I think is really important. And good clinical advice to someone, and having something we can measure against, I think is really important. I only raise one issue because we're lawyers, we're worst case scenario people. I was speaking to someone recently who said to me that they thought that there may be an unintended consequence pre-employment. So I'm not talking about screening post-employment, but pre-employment, if we focus too much on screening, because would we get to a world where we start screening people out before they get the role? And would that then mean that some people who, for example, may have some, neurodiversity don't get particular opportunities? Now, that's a huge summary of a much more complex issue. And certainly we have protections at law in relation to discrimination. But I just think we need to keep an eye on these things and be careful about the use of screening. It's an important tool, but it shouldn't reduce diversity and deny people opportunities without a good clinical basis.
Yeah, and it's definitely a point that I've taken up on LinkedIn before, because there are some people who are, saying we should move beyond even further than psychosocial risk management to biopsychosocial. But then there's that point of discrimination then, right? You might not actually be allowing people into a role, based on neurodiversity or some historical illness or something like that as well.
Yeah. And, how do we define what are those characteristics that people need for particular roles? If we become too limiting in them, even if we guard against discrimination, are we getting the best result in a world where we want to recognise diversity? I think it's a really interesting and complex problem.
So I think, to Joelle's point, she was talking about monitoring during the period of employment.
So not pre-employment, but as just a periodic, let's check and see sort of how your mental health is. And, we've got sort of baseline and historic data that we've collected or assessments, and we can see now suddenly that you've had a pretty sharp drop. So let's explore that. But obviously something like that then needs to be combined with a very well-crafted response from the employer should that situation or when that situation occurs. Because if it's just, oh, well, you can't do the job anymore, you're out of here, and we'll performance manage you out of the role, then obviously you're not going to get people participating honestly in that screening process in those situations. So it's not as easy, I think, as just sending somebody to a psych every 6 months to check how they're going. You actually have to think very carefully about, well, how do we respond when we get a report back from the psych saying this person isn't doing so well?
Yeah, look, I think that the point's excellently made, and I think you combine it with good job design and you combine it with managing expectations, and you also need to be putting the time in to have those conversations. And so, in this case, it doesn't look like anyone really had the time to do it, but you actually need to devote time to so that these are not rushed. And there's actually time put aside and then a good discussion about what does this look like. So even if you are passing, for want of a better phrase, your screening, well, what else are we looking out for? Reminding people of these issues, we need to test you again in a certain period of time.
Yeah, or just, this has been a really tough case. Let's sit down and have a chat about how you're doing.
Yeah, that's right.
One thing you mentioned, Catherine, earlier was about reasonably practicable. So what were the reasonable steps that the employer had not taken according to the judgments?
Sure. So there were 5 key steps that were identified. These were that there wasn't adequate training of management and staff on things like vicarious trauma, symptoms of PTSD, how to recognise when intervention is necessary. There was not an active OH&S system. In fact, the trial judge called it woefully inadequate because the measures that were put in place were just absent and the policies weren't implemented. And as I've said, we had leaders of this particular unit who were unaware of the vicarious trauma policy. And there was no OH&S committee. It doesn't look like there was a lot of collaboration. So we're not getting that buy-in that you would expect if you had good consultation in the workplace. There were no real systems of welfare intervention. So, if there were red flags, there were red flags there. It's not clear how someone would pick them up and then what would be done. There was not the occupational screening that Joelle talked about. And then there wasn't the flexibility about casework and allocation and rotations. And so, some of those features are features of a number of busy workplaces, and I think underline the importance of being prepared to consult, being prepared to discuss workload, and actually then being prepared to adjust it, which as I mentioned, I think in a world where we have a lot of labour shortages is really important. We can't necessarily do things long term at the moment because we can't fix it, but we can do what we can to manage those issues now.
Yeah, I mean, definitely if they're saying a reasonable caseload is 20 cases and some people have 100 more than that, then that's ridiculous in terms of the work demands.
It is, but it's a really complex problem. What if you've got that many cases and the judges are calling them on and you don't have the budget to hire more people? I mean, I'm hypothesising a little here. I'm not trying to put myself in the position of the public prosecutor, but what do you then do?
Well, as an employee, you work the hours that you're paid to work, and if you can't fit it all in, then that's too bad. The employer has to find a way to deal with it, right?
I know, but that's as someone who's often dealt with the wrath of judges who say, "Well, we want all this yesterday." It's actually really difficult.
Yeah, and judges obviously judges are obviously going to be more of the old school, given that they get there through experience, right? So, obviously, some new mindset shifts that have to happen in that peer group.
I think there's also just that aspect though of, I mean, especially something like this, working in sexual offences, how can you say no to acting to prosecute these people and acting to protect these victims? Like,
it's definitely one of those mission purpose kind of roles.
Then you're going down the moral injury pathway because you've had to make this this decision to protect your own health, but then who's going to stand for these people who've been harmed so horribly.
But it does raise an interesting quandary, right? Because you have employees who are making sure that the work gets done, even though they might be harm to themselves, which doesn't then escalate up the chain that there is an issue because the work is still getting done.
Yeah.
So yeah, there's some real issues there.
Shortage. Like if there's a shortage of trained people or people you can bring on, now I accept you can always try and find solutions to that, but they are not often short-term solutions, and you're dealing with an immediate issue. So whether it be you've got, a royal commissioner insisting that you produce a whole bunch of documents on behalf of a client, or we have, matters that need to be heard because they're otherwise going to be statute barred in a court, or we have, public servants who have appropriate expertise in emergency management and public health who are called on to manage a COVID pandemic and are, on the tools around the clock for the best part of 2 years. Those are really high job demand and often quite public matters. It's very difficult. It doesn't mean that there aren't things that can be done. Picking up your earlier point about we can't just say exposure to risk in sexual offence work is inherent, but it's a really difficult issue. And so I think having the framework of the psychosocial regulations and having, a new hierarchy of control to work with will be really valuable for employers to actually give them tools to work through these issues so that we don't go back to, well, try and find time for yoga and pottery classes and call the AP if you're suffering. We actually have a more reactive approach. It may not necessarily reduce risk, but at least we've tried as many options as we've got.
Absolutely.
So the findings of the trial judge included a description of a safe system of work. Can you share that with our listeners, please?
Sure. So the trial judge said it involved an active OH&S framework, more intensive training for management and staff regarding the risks posed to vicarious trauma and PTSD, welfare checks and the offer of referral for a work-related or occupational screening in relation to staff showing heightened risk, and a flexible approach to work allocation, especially when required in response to screening, including the option of a temporary or permanent rotation from the unit where appropriate. I think all of that's right. I touched on some of these points before, I just think it's really interesting that much of that is reactive, not proactive. This is not looking at job design. What do we expect of people in this area? Can we job share? What else might be available? It's all, with the exception of the training to be aware of symptoms, it's all, well, at a point where there's a problem, we will do something. It'd be interesting to know what proactive options are available in this space. I also think the judge also said it was important that there be collaboration with staff about an active OH&S response, and that there be reasonable working hours and conditions, and that risk management involved training. So again, a little reactive, but I think all of those things are things that we would all say are important, in an environment like this.
Yeah, I think you could probably argue that having scheduled rotations in and out of the unit is a proactive sort of prevention approach, recognising that, that exposure to that ongoing traumatic content is going to be cumulative. And so, it's by doing that periodic rotation, you are actually preventing the development of vicarious trauma or PTSD.
Yeah.
Yeah, and actually one thing that's been brought up by Nicholas Wisen brought this up, as well as I think Jackie Wilmshurst as well, dealing with content moderators in her case. His case was, I think, in trauma wards or something like that in healthcare, having a green light, orange light, red light system for the cases that they're working on. And so that, if they're getting heaps of red ones, for example, they're not allocated more red ones. They get, green or orange ones. So they're still getting to see matters and work on cases. But, we're kind of being mindful of, hey, this one's probably going to be less.
Distributing the hazard across a broader range of employees.
Yeah, seeing if an individual is being unfairly loaded where other people could have capacity. Yeah.
I mean, I also think a fascinating thing will be what the flow-on effect this has for employment contracts and industrial agreements. Will we get to a world where we do, I think we should, where we do proper risk assessments before we enter a bargaining period? And so we actually say, there has to be the right for an employer to be able to insist on rotation after a certain period. Or we're going to manage fatigue in this way so we don't actually reward people who want to work long hours by the fact they get lots of additional pay, which creates an incentive for some people to work very long hours, but it also means that there's an inherent risk. I think these are all the really fascinating issues that we will see play out of a better approach to job design as part of what employers will be required to do under the psychosocial health regulations. I'm not sure that regulators will necessarily want to stray into that kind of semi-industrial area, but I think some employers will. I think they'll say, we haven't been able to rotate people because we haven't been able to agree on that industrially, but now here's a health and safety reason why we have to. And that'll be just, I think, a really interesting.
That was one of the arguments in this case, wasn't it? That that something to do with her employment contract meant that she couldn't be rotated out, and she argued that the WHS duties superseded an employment contract.
Yeah, and that had she been offered and had she been asked earlier and given various information, then she would have self-selected earlier to do those things, and so that was absolutely an issue. And effectively that was the difference between the High Court decision and the decision of the court below. But I just think it's a fascinating topic that maybe we'll touch base again in a few years and see whether or not any of this has come to play, or it's in the too hard basket for a while.
Yeah. Now, something that you've referenced a couple of times, Catherine, is the incoming psychosocial regulations.
Yes.
We've seen the consultation period come and go for the Victorian ones, and then the model workplace health and safety draft regs have just come out in various mediums or in certain forums. It's come out. Actually, I caught up with Libby and her team from WorkSafe Victoria last week, and I tried to get out of her unsuccessfully when they expect to publish the new regs. It was in the draft that they were expecting to publish on the 1st of July. I don't think they're going to get there, but we'll see. But, like you've referenced, all of this High Court decision was made in the absence of these new regs.
Yeah.
So, what changes do you think will happen? What new obligations will we put on employers, not just from this finding, but from the new regs that are coming in place?
Yeah, certainly. So the Victorian ones have three essential elements. The first is basically a risk management process for psychosocial hazards. Some of those psychosocial hazards are defined in the draft regulations that we've seen. So it's an inclusive definition. It's not everything that's defined there. And interestingly, it uses slightly different language from the Western Australian Code and slightly different language from the New South Wales Code, which I think is going to be the problem we will have for the next few years. But that risk management process obviously needs to involve consultation, and it involves both employees and contractors for 5 particular sorts of risk, which include vicarious trauma, high work demands, occupational violence, I think I've got this right, bullying and sexual harassment. You need written prevention plans, which again you need to consult on. And then in due course, there will also be a requirement to report with a prescribed form to provide detailed complaints of particular sorts of things like occupational violence, bullying and sexual harassment, with then an obligation to go back and review your risk assessment process in relation to what's come out of that complaint. So what I think is really interesting about this is there's a few things that I think are interesting. I think it's going to increase fluency. I think in discussion of these risks, I think the process of talking to your employees and consulting for those employers that do it correctly will mean we have a better dialogue and a better recognition, which I think will be both good, but will also lead to people raising things like high work demands more often, which some employers I think won't welcome. I think it's going to mean that where risk assessments are done properly and where you do have to apply this kind of changed hierarchy of control and look at job design first, that'll raise a whole lot of complex and interesting issues which won't be able to be solved within a year or two. They're going to require ongoing assessment. For example, fatigue, if your industrial agreements lock in certain arrangements, then there may be little you can do to manage fatigue until the next time of bargaining comes, but you've got to look at what else you can do in the meantime. So those issues I think will be interesting. I think the challenge for a lot of organisations will be how they consult on this, how they actually think about ways to eliminate and minimise risk that doesn't go straight to, we'll revise our policy, we'll have more EAP, we'll do a bit more training. And I know that's at the lowest of the hierarchy of control. And in Victoria, you know, the regs would say you can't go there until you've considered job design. But I think it's just the default way of thinking for so many employers that it'll be difficult to move out of this space. And then I think there's questions about how you measure psychosocial hazards and how often you review them will be really interesting. So I'm speaking to a lot of employers about this now and saying, well, you know, don't do anything yet. You need to wait and see what the regulations actually say when they come out, and then we need to see what the regulator's compliance code tells us. But it's going to be a challenge. The fact that, you know, it's many hundreds of thousands of dollars worth of expenditure expected for employers of certain sizes in the first year. I think it's, the regulatory impact statement says it's for employers with over 200 employees, it's about $604,000 worth of management time. That's a huge investment, which some employers won't have the funds for to do this properly. Done properly, it's a great opportunity, but I fear that some employers won't do it properly, and then we'll have wasted that opportunity.
Yeah, I mean, obviously it's good and bad that the regs aren't prescriptive. It's good that it gives flexibility to employers, but it's bad in that they can probably do a tick the box kind of exercise, and then it doesn't have the desired impact that we're after.
Yeah, I think that's right. But, you know, that's probably true for all safety issues, really, isn't it? We can introduce due diligence requirements for officers. We can introduce workplace manslaughter. We can do a range of things, and yet some employers will still complain about safety clutter. They'll still not have safety officers or consult. They'll still disregard advice from health and safety professionals. It's the lot of working in this area, I think, that we constantly have a role in trying to persuade people to do something that's good for business and good for their people and is required by law.
Yeah, so hopefully we get a really good intersection here of the moral and legal obligations, right? So I think the majority of employers want to do the right thing by their employees, and they understand that good mental health is good for business. And hopefully if they follow this in the way it's intended, then that they will actually see those mental health benefits much better than obviously the downstream, more reactive interventions that we have seen popularized. One thing on the measurement and consultation piece I found quite interesting in the draft model regs was, which hasn't been approved by ministers at this point yet, but it looks likely to go through in this kind of way, but around when consulting with staff needing to consider the severity, frequency and duration of hazard exposure and the combination of hazards together and how they contribute to psychological injury risk before implementing controls. So it means that you obviously need to do a decent level of consultation. An employee engagement survey, for example, would not give you that information about severity, frequency, duration of hazard exposure. So obviously you need to do a separate consultation here.
I agree, and I think you also need to potentially consult with different groups depending on different risks. So, you know, if we think about the risk in sexual harassment, you know, we know it's mostly women, although not exclusively. We know that intersectionality plays a role, so we would consult with our LGBTQI employees perhaps separately. We might engage with very young workers or workers who are new in the workplace, who are in have much less power relative to others because they are at greater risk. We might consult with our called workers because they will be able to tell us more about sexual harassment than just including those workers in let's get everyone in this area to consult. And so I think if we then apply that across other risks as well, what might we do when we think about high work demands? We would consult in this situation with our specialist sex offences unit separately and talk about workload and talk about what can be done, so that ability to consult based on risk and based on profile, I think will give employers who do it a rich vein of information that they probably don't have full access to now because they're not asking those questions. And for those employers who are still uncomfortable, or leaders or managers who are still uncomfortable with that conversation about mental health, you know, this is the opportunity to say, this is your forum to do it. So this is actually not intrusive and it's not personally offensive. It's actually your chance. So that may well be revolutionary. I think some people will, you know, I've done it with a few employers where we've gone in, you know, and they've done very specialised consultation on particular issues to deal with psychosocial hazards. and they've come out saying, well, that was just mind-blowing. That was the most valuable thing we've done all year. So I'm optimistic about that side of things, but it's, it's going to involve quite a bit of time.
Yeah, and that's definitely where Joelle and I and the team want to have impact. Helping companies to do a good depth and breadth of consultation. I definitely don't think it's the case where you can just have a group of health and safety representatives in a room and do a top-down risk assessment and actually fully understand all the hazards. Particularly, as you say, they can be different for different demographics. They can be different in different units, and we know, obviously, even team to team, even if they're doing the same work, because a lot of psychosocial hazards are interpersonal. We think about leadership behaviours, peer behaviours, civility and respect, those sorts of things. It's not even a role difference, it's just a team difference. So depth and breadth is really important here.
And I think also just the impact of the interventions or control measures can be so much more significant when you're really targeting it to the hazard profile of that particular group, because you're able to actually see, rather than just averaging across an entire organisation, and you're not going to see where those real hotspot or danger areas are. But by going down to that team level, you can get a much better picture of what are the hazards that are actually going to cause a psychological injury for our organisation, and let's target those in our action planning and be a lot more focused. So you're getting a much better outcome for your effort.
Yeah, absolutely. And, I think it's really important that people do get, really good advice if they're not skilled in doing risk assessments, because it is a skill, right? And so you will see leaders who do it in a very light touch way, because they don't realise the information that's available and the questions that can be asked. Yeah, it'd be fascinating to see.
So what are the main lessons you think employers should take from this Kozarov case?
Yeah, I think there's a few. I think I think this should be apparent, and maybe it is, but just to make the very clear point that discussion about someone's mental health, particularly if they're exposed to traumatic work, is a discussion that employers have to be having. They need to be asking the question. I also think it's a good reminder that we can find out a lot about what the red flags are and what to look for. And so if we're looking for things, we will be in a better position to find them and then take action early and prevent what may be very significant mental health harm. So those two things together, I think, are really important. Being willing and able and ready to have the conversation, and knowing what else to look for, I think, is really important. And the third one, I think, is probably just one that I would say is something I often come across, which is not to normalise safety risks just because they're there all the time. So it's that point you made earlier, Joelle, about, yes, it's inherent in this work. It doesn't mean that we have to accept it. So I often, when I'm talking to my clients, I wish I had $1 for every time I use this phrase each week. I talk about actually putting on your safety lens, seeing your operations with a different lens. And sometimes it's about actually making time, on a Friday in your diary to think, what's going on operationally? What are my people doing? What is the work? And what are the safety issues that come from that? Because it's my role as a leader to take responsibility for safety. And so I often won't put on that safety lens because I'm thinking about budget, or the fact that someone's not producing work in a particular way, or they've gone on leave and it's created a problem. What does that tell me? We don't have enough budget because we're paying people to do work and we don't have enough people on, and we've got a high workload, and this person's taken leave and they took leave last week and they took leave the week before and they look exhausted. And so what should that tell me? It's those sorts of safety focused views that good leaders need to have in this space.
Yeah, good advice there. Thank you, Catherine. And I guess just expressing our best interest to Ms. Kozarov as well. And we hope that she's able to move forward now that this matter is resolved.
Yeah, I think that's really important. And I think, if for those of you who read the case, and particularly if you look at the original decision, it's a very long decision. There's just a lot of people in this space, including the managers. Everyone was working incredibly hard and doing a job I just can't imagine. So just awful all round.
Yeah, Catherine, thank you so much for providing that overview. I'm really glad we're not paying your hourly rate today. I Look, I've been aware of this case for some time and been following it, but haven't gone into the depths and the detail that you have today. So I think, look, I really appreciate it. I'm sure our listeners will really appreciate you unpacking it in the way that you have today.
Great.
But we're not quite finished with you yet, Catherine. So one of the questions that we like to ask all our guests is, if you were to look into the future, what would your hopes for the future of workplace mental health be?
Oh, great question. Look, I am hopeful, despite the fact that, as I said, I'm a lawyer, so one becomes a bit of a professional pessimist. I think we're in a brave new world where we are having conversations that we were not having, 5 years ago, and there's an increasing maturity and fluency in the conversation. And in a strange way, I think the experience of COVID, and this may be a particularly Victorian-focused experience, but the experience of COVID, where we've been, in each other's rooms and seeing the difficulties people have had, have meant we're much better at doing those things. And so I'm really optimistic about the role that colleagues and leaders can play in looking out for each other. I think whether it's these regulations that we expect in Victoria or other regulations, the fact that we will have a form and a framework to have those conversations in, I think is also really exciting in this space. It's a really good opportunity to do more.
Yeah, terrific.
And last question for you today, Catherine. Do you have any words of advice for listeners who would like to work in the field of psych health and safety?
I think a lot of time we're dealing with managers and leaders who have a lot on their plate. And so I think it's about making life easy for them in this space. So that's not to let them off the hook, but it's to give them the tools to operationalize safety and to feel really comfortable having conversations in this space. And so I think, things like this podcast and discussions about that, that take this out of a technical realm into a very practical realm are really important, because anything we can do to make this just part of everyday business as usual makes a big difference.
Wonderful. Thank you.
Yeah, great advice. Catherine, thank you so much again for taking the time out of your busy schedule to share with us, your thoughts on this case. And we'll be looking forward to keeping in touch and hearing more about. I'm sure. Actually, we didn't touch on it. I don't know if we discussed it. Do you think there's going to be more cases? With the new psych health regs coming in, do you think we're going to see a flurry of cases come in?
I suspect we will. I think only because I think once we introduce the phrase high work demands into the vocabulary, we will have people who will use it as a reason to say, to defend against performance issues, or to say that they're being expected to work at a level that they just can't work when employers say, I can't hire someone. So I think that will be really fascinating to watch. And maybe it's not a bad thing, although many employers, I think, are worried about it. But yeah.
So we won't say goodbye to you then. We'll say see you later. I'm sure you'll come and unpack some other matters at a later date.
Absolutely, indeed. Well, it's really great to speak to you guys.
Yeah, thanks for your time. So listeners, that brings us to the end of this fantastic episode. If you want to watch the video rather than consume the podcast, although you probably just finished listening to the podcast now, but just be aware that we do record these over YouTube, so you can check that out on the Flourish GX YouTube page. Also, we do take snippets of these and put the best snippets on the Flourish GX LinkedIn page if you want to follow along there. While you're on LinkedIn, you can connect with Joelle and myself. We always love to continue the conversation over that medium. So that is the end. We will catch you next episode.
You've been listening to the Psych Health and Safety Podcast. To stay up to date with the latest on psychological injury prevention, follow Flourish DX on LinkedIn and subscribe to the Psych Health and Safety Podcast at www.psychhealthandsafety.com.